But here you are trying to express your concern for your child. You had a responsibility at that time, which you neglected. Let me read this from the victim. He doesn't think a 10-year prison sentence is sufficient. This man believes it was God's will that he didn't get killed because it was a matter of luck or providence that he wasn't shot and killed. And if you would have been able to fire the gun, it would have probably been fatal. We now call two cases, 23 CR 188 and 189, the state of Texas versus Jamarius Spraggins. These are attempted aggravated assaults with a deadly weapon, a third-degree felony on each case. That's you, sir?
Yes, sir.
Here with your attorney, Mr. West, and the state's attorney. All right. I see the plan is the defendant is going to be pleading guilty to 188. No, it's on both cases?
Yes, sir.
Is that right?
Yes, sir.
Yeah. It's only 188 is the only one that's on the docket, but I guess that was just a mistake.
We're going to run CC. That's yes.
All right. So there are actually two cases before the court, 188 and 189. Looks like earlier in these cases, the defendant had pleaded guilty to these third-degree felonies. Pre-sentence reports have been prepared. If the parties had an opportunity to review it, any corrections or changes to them?
No, not mistake.
They're made a part of the record for all purposes. The agreement in each case, a cap of 10 years confinement, though, to run concurrently.
Yes.
So he's looking at up no less than 2 nor more than 10 years confinement, but whatever sentence the court assesses, the cases shall run concurrently with each other. So go ahead. A defense may go first.
Your Honor, the two big issues I want to point out on this case, or the court, we'd like the court to take into consideration.
Yeah.
One is my client's taking responsibility for this and pled guilty and is accepting responsibility for his involvement in this matter. The second thing is his age, Your Honor. He is young. He is before he was arrested, he was in high school. I mean, I guess he's still in high school, but it depends on what happens here today, obviously, because if he is sent to prison, then he'll have to do a GED later. But we think it's a situation where, from talking to him and kind of getting an idea of what's going on here, Your Honor, is that he was caught up with the wrong people, the wrong place, the wrong situation, just everything in a bad situation. And he's asking the court to give him a chance. The court could, in this case, give him deferred probation if the court determines that's right for him and society. We believe it is. We believe that due to his age and his the situation, we would request the court to consider probation in this case. It's one of the things that we send him off to prison. What's it really going to do? It's going to lock him away for up to 10 years, and then he's back, and there's nothing's really changed in his life. However, I believe he's young enough that we can make a difference, or the state can make a difference in his life. Put him on probation, get him some guidance, make sure he stays on the right track. And if he doesn't, then he's off to prison. It's on him. But at least give him a chance to try to do what's right and to make up for this and make him a better life and do better for himself.
Okay. I understand.
Judge, he got the biggest break in the world by being charged with what he's charged with, because he was a party to a murder and an aggravated assault. And just because his gun did not fire, he gets a break of what the grand jury decided to indict him on after being presented by our office. But there was somebody killed and another person injured, he lost his life, his livelihood, his job, everything, because of the injuries he sustained as the other victim. So what would be accomplished by putting him in prison for 10 years? Justice for the victims, that one that was murdered, one that was shot. I mean, these people came from another county over to a party, and they brought a whole busload full of guns and ended up shooting and killing one individual and wounding another. And the only reason that Mr. Spraggins wasn't charged with the murder was because his gun jammed. And otherwise, he might have been the one that actually fired the deadly shot that killed him. It was shooting. It wasn't like he wasn't pointing at his shooting. So we would ask for the 10 years on both cases.
Anything else?
Your Honor, again, and I'm not going to minimize the offense, because it was a very serious offense. But I am going to point out the fact, like I said, that's why I started my arguments with it. Wrong place, wrong time, wrong people. He was in a bad situation with some bad people doing bad things. And that's where I'm getting at, Your Honor, that putting him on probation and giving him the guidance and making sure he stays away from bad people, bad places. We put him in prison. Yeah, there's justice. But then in at most 10 years, he's out or less, or whatever the government decides to keep him in. And then he's back to the same actions. And this is something where we might see him again in 12, 13, 14, 15 years and over again. Whereas the court has a chance right now to divert that and maybe say, look, I'm going to give you a chance. You're young, was stupid, whatever you want to say. Put him on that probation, get him that guidance, and make sure he lives the straight and narrow for the next 10 years, however long the court wants to keep him on probation, to make sure he does everything he's supposed to do. And then maybe in 10, 12, 15 years, we don't see him again because he's had that guidance, had that help. And that's my argument. I know the state has a different argument, but that's our position.
Anything else you'd like to answer? Anything you want to add?
Yes, sir. Speak real. Just like I told my attorney, I was at the wrong place at the wrong time. I was intoxicated. I didn't know what was going on. I just heard it was a lot of commotion. So me going my first mind being intoxicated is all I. But I ain't planning on hurting nobody, because if I did, I would have did it. But I stopped myself from hurting somebody that night. I got a son, birthday today.
How old was your son?
He just turned 3. And I'm just trying to get home to him.
Anything else? No, sir. Let me just take a moment to respond to a couple of things you've said.
Yes, sir.
Number one, intoxication is not a defense.
I already know, sir.
You brought it up. Let me speak.
Yes, sir.
You brought it up. For whatever point it was, voluntary intoxication is not a defense. Whatever you do while you were voluntarily intoxicated, you have to accept responsibility for. Number next, hanging out with these people, you knew better. You made a choice. Number last, which is the worst thing, you throw your child in front of this court and try to hide behind your child. Oh, yes, I've got a child. At 2:30 in the morning when this was happening and you were trying to shoot and this guy almost got killed, your child was at home somewhere asleep. Why weren't you being the father you were supposed to be? If you were, you wouldn't have been out there. You wouldn't be in here today. But here you are trying to express your concern for your child. You had a responsibility at that time, which you neglected. Let me read this from the victim. He doesn't think a 10-year prison sentence is sufficient. This man believes it was God's will that he didn't get killed because it was a matter of luck or providence that he wasn't shot and killed. And if you would have been able to fire the gun, it would have probably been fatal. That's what he says. Far too often in this court, we see the same old thing. People with foolish decisions. Later on, they try to explain them away. This is such simple stuff. Who points a gun at another human being and fires it or tries to fire it? When you got responsibilities at 2:30 in the morning, you're out there frolicking and having fun with guns. People's lives are in danger. Your responsibilities, your children are at home sleeping where you should have been taking care of them, and this wouldn't have happened. I mean, how many things do I have to check off that you did wrong here? But that's typical that comes into this court, this kind of behavior. And it's wrong. It's irresponsible. And it is going to cost you. I just wish you would have acted more responsibly. I'm going to find in each of these cases, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in 23 CR 188. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. In 23 CR 189, I'm going to place you on deferred or unadjudicated probation for 10 years to run concurrently with this crime. You are ordered as a condition of probation to pay restitution in the amount of $16,500 to Armando Camargo Jr., the victim in this case. If you fail to do that, your probation can be revoked and you can be sentenced up to 10 years in prison. In the 188 case, the judgment will reflect that a deadly weapon, namely a firearm, was used in the commission of that offense, which means you're not going to be paroled until 50%, 4 years or served, and you're going to be on probation. At the same time, you will be released, put on probation, and I expect you to pay this guy, this poor man, back for the horror you had to put him through. You understand what's happened today?
Yes.
You're talking about responsibilities. Well, we'll see how you handle this responsibility. Do you understand?
Yes, sir. Judge Steve, can I have a moment with you, sir?
No, sir. Yeah, no, you can speak, but you don't have a moment with me alone. No. What did you want to say?
I would just, could have been worse. Thank you for doing that for me, sir.
You got a family. I mean, your life touches other people's lives. You acted selfish. You acted as though no one else existed. No one depended upon you like your child, your family. They do. All you're doing, like so many people in this courtroom, is just thinking of your selfish needs and whims. And here you are. You're no longer free. You've lost that. Someone almost got killed. Good luck with that on your soul if you have to deal with the intentional taking of a life. That's a terrible thing.
All right, Mr. Shunke, have you already spoken to Ms. Hart?
I have, Your Honor.
Okay, so we're on the record in the matter of the state of Michigan or city of Wyandotte versus Jamie Hart, 232371. And appearance, counsel.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
And Ms. Hart, your name, please.
Jamie Catherine Hart, H-A-R-T.
All right, and counsel, as to the arraignment.
We wait for more reading. My client stands mute.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and we will schedule this matter for pre-trial on November 28th. At 10 a.m. And counsel, as to bond.
As to bond, judge, my client does not have lodging, and she may have another case in another city. I don't anticipate a personal bond being advantageous for either party. I would anticipate asking for the earliest court date so that she can try to get this matter taken care of as soon as possible.
All right, so ma'am, do you believe that your other case is in Livingston County?
Yes, ma'am.
And what is that for?
That's for being charged with a third DUI.
And you're charged with public intoxication as one of your charges. Why haven't you taken care of the matter from Livingston County that's been pending since March?
It's like been kind of stranded down here in wherever Detroit or Ecorse where I've been at. I haven't been able to have any vehicle to get me up to Livingston County. I've been homeless. I haven't had a phone. There's been numerous things that have been going on since I've been down here. I've been stranded, and it's been a rough time, to say the least.
I show your address in Ann Arbor. How long has it been since you've been in Ann Arbor?
It's been since February. That was at the homeless shelter in Ann Arbor, the Lions Center. I actually was supposed to be going to rehab today. Unfortunately, things happened yesterday.
And which rehab were you supposed to be going to?
Oakdale and Canton, Michigan.
And how are you supposed to be getting there?
They were going to come pick me up wherever I was going to be at. They come and get you. I don't have a problem, and I want to get it fixed and taken care of. I don't want to be on the streets anymore. I don't want to live this life anymore.
So what would be detected in your system other than alcohol?
What's that?
What else would be detected in your system other than alcohol?
Probably some cocaine, crack, marijuana, crack.
Okay. Here's what I'm going to do, ma'am. It appears though you have a warrant out for your arrest out of Livingston County. You are homeless. And for your benefit as well, the court's going to order a $7,500 10% bond. The court will order that you may be tethered to treatment. Through the Wayne County Jail upon your request. And you're not to possess or consume any alcohol or drugs unless prescribed. And in the event you post bond and you're not going to treatment, Wayne County Jail, GPS tethered through the Wayne County Jail. All right, anything else, counsel?
No, Your Honor.
All right, thank you. All right, off the record. Have a good day.
Thank
you. Mr. Perez, okay. Sorry, I couldn't see the person sitting on the chairs. All right, we're on the record in the matter of the state of Michigan versus Jose Perez, 232372. And Detective Sergeant Grote, your name for the record, please.
Detective Sergeant Ken Grote.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You may proceed on the word.
I'm signing this on information and belief for Detective Sabo. On November 10th, 2023, approximately 9:50 p.m., Officer Cox was on patrol in the area of Biddle and Goddard in the city of Wyandotte. Officer Cox saw a Cadillac Escalade driving southbound on Biddle. Lien check of the license plate showed the plate to be expired August 25th, 2023, vehicle that had no insurance. Officer Cox stopped the vehicle and spoke with the driver, later identified as Mr. Perez. Perez stated that he was aware that the plates were expired. Officer Cox observed an open container of beer in the center cup holder. Mr. Perez did not have a valid driver's license. He only possessed a Mexican identification card, and he told Officer Cox he was in the country illegally. Lien checks of Mr. Perez showed his driving status. He did not have a driver's license. During the search incident to arrest and an impound search, there's located 11.5 grams of field tested positive methamphetamine in a glass case that was in the center console.
All right, thank you. Upon examination of the complaining witness, I find the offenses charged were committed and there's probable cause the defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shefke appearing on behalf of my client.
All right, thank you. And Mr. Perez, your name, please.
Jose Perez.
All right, and counsel, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute. We consent to the matter being heard via Zoom.
All right, thank you. The court will waive the formal reading and enter plea of not guilty for purposes of the arraignment. I'm sorry. And sir, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
You spoke with an attorney today?
No.
You spoke to the attorney today?
Oh yeah.
Okay. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You also have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yeah.
Sorry?
Yes.
All right, the court has already entered a plea of not guilty. The court's going to schedule this matter for a probable cause conference on November 22nd at 8:40 a.m. And counsel, as to bond.
Your Honor, my client's 25 years old. He indicates he's not on probation or parole. He does work independently doing drywall. He rents in Detroit. He is giving assurances to the court that he will appear at any all future court dates. So we will respectively request leniency when determining an appropriate bond. Thank you, Judge.
All right, thank you. Mr. Perez, who do you live with?
I'm still paying rent.
Who lives in the house with you?
It's I live with the woman and her brother. It's a friend.
All right, Detective Sergeant, as to bond.
Your Honor, being he doesn't have any ties to this state, he's here illegally. To assure his appearance, 5,000 cash would work for us. No 10%.
Has ICE been contacted?
I'm sorry?
Has ICE been contacted or anything?
Not yet. I'm going to call him when we're done here.
Okay. Mr. Perez, are you out on bond in any other matter?
How today?
Are you out on, you been in trouble recently that you're out on a bond from court?
Oh no, I've been in trouble before.
I believe that's a no, ma'am.
Did you say you've never been in trouble before?
Long time ago, like long years ago. Like what's it mean? Like 8 years ago, 10 years ago.
Okay.
Something like that.
All right. How long have you been in the country?
3 years.
All All right, the court has concerns that Mr. Perez will not be reappearing for court. It shows, even though he's indicated that he works, he shows zero income. He rents from somebody. He's not here in the country legally. And the allegations with what Mr. Perez had in his possession is concerning for the safety of the public. The court's going to order a $50,000 10% bond. In the event you post bond, you're not to be released without a GPS tether through the Wayne County Jail. Not to possess or consume any alcohol or drugs that are not prescribed. All right, and we'll see you back next week. Thank you. And the court did sign the order for court-appointed attorney for felony matters as well. All right.